Just waiting for YouTube to get moving.
Who, me?
No. All right. Well, here we go. Good morning, everyone. This is JJ Risha with Pismo Ventures, and I have with me today Joe Daniels. Joe just moved to Nelson Mullins, a large law firm out of New York. I'll let him explain to you what he's doing, what he does, and the firm that he just moved to. I'll get started by just giving you a little bit of an update of what we're doing. Pismo Ventures is a venture studio. We help startups with their startup needs, help them to get ready to be investable, and also we invest in them, and then we help them raise capital. The Startup Symposium series of events that we have is starting with life science. So this is the first year we do this, where we have a life science only event. And then we should have upcoming this year a B2B event and a B2C event as well. But life science is usually a different animal on its own because of the the way life science is and all the different functions that it has. So this event, we had 100 companies apply to the Life Science Symposium. Our selection committee selected 12 companies that will present on Thursday at noon Pacific time. So out of those 12 companies, potentially we'll have 3 companies that rise to the top, and the 3 companies will be exposed to more investors and VCs across the nation. So it is, if you'd like to join us on Thursday, please do so. All the applicants are already pre-registered for the event on Thursday, so you're welcome to join. I think that's about it for me. If I will let Joe take it from here.
All right. Thank you, JJ. I am Joe Daniels, a partner and co-chair of the emerging companies practice at Nelson Mullins, this firm name right here. This is my presentation, Structuring Your Startup and Negotiating Financing. You're going to see what we're talking about in my agenda slide in a little bit, and we'll actually survey you about that. So a little bit about my firm. It's a 125-year-old firm. We have startup to Fortune 50 clients, 1,000 lawyers in 43 states and in 30 offices across the USA, but we have a global practice given the interconnectedness of global commerce, and a 70 lawyer strong emerging companies group representing startups and venture capital firms and private equity firms as well. I'm the co-chair of that practice. I think it's highly ranked. We focus on formation, financing, growth, and exit. What does that mean? Helping the companies form correctly, structure themselves correctly for venture financing. Then, of course, successive rounds of angel and venture, with different terms, obviously, and growth through acquisition, partnership, and commercial agreements, and joint ventures, and then exiting through a merger, acquisition, or an IPO. We're consistently among the top firms in the pitch book and in Chambers and Partners in the emerging company space. We obviously represent thousands of startups and funds. And for example, in 2021, we did about 200 deals for more than $8 billion. We're backed up by 150 M&A lawyers and 40 plus capital markets lawyers for IPOs and follow-ons. And I do both of those types of transactions as well. And we have a 60 lawyer IP group with specialists in most technical areas. And they handle especially in tech and life sciences, they handle patent, trademark, and copyright prosecution, litigation, and licensing. And 550 litigators ready to sue and defend all over the US. I've been doing this for about 26 years. By this, I mean that financing, growth and exit stuff. And including 8 in California during the dot-com days in the group that took Netscape public and sold it to AOL. Also where, Genentech and other, lots of, biotech and life science companies are located. Here are some of the bigger companies in the life sciences side. Invitrogen LifeTech which was then sold to, I can't remember, some big Swiss pharma is probably, the most widely known. And I've also represented Universal Health Services, which is the biggest owner and operator of hospitals, psychiatric care facilities in the US. In terms of private equity and venture funds, here are some names, investment banks as well. I represented them on the underwriter side of IPOs. I've done about 25 of those and follow-ons, scores of M&A deals and thousands of financings all over the country, all over the world, really. And again, I focus on tech and life sciences. So on the agenda, we'll talk about how do you form that company correctly? How do you protect the equity with vesting? How do you protect the IP with agreements? It's essential when you add people to have that. What is IP and basic IP protection methods? And then raising capital, both pre-seed and seed, A, later stage rounds, and strategic. This is a lot of content here. And so we might want to trade off. Why don't we survey the audience and everybody interested in seeing or hearing about raising money more than what is IP, just indicate that in the chat. And then we'll figure out, who's the winner. And I'll just
raise your hand and then we'll count those as well. So if you want to raise your hand, this would be for more about raising capital, less on IP.
Yep.
All right.
Which would save more time for Q&A at the end. Okay. So we're going to start on formation. So what is a startup? This is a little diagram that helps explain it. You're probably the founder, CEO. You're contributing the intangible assets of the business plan and perhaps some IP. And of course, you have to add on other, what we call service providers, whether they be consultants, employees, advisors, or interns, and they provide services. And then the investors invest their cash in exchange for equity. The key point is that the startup company is the legal person that owns all of these things contemporaneously and at the end of the day. And that allows all these people to have, certainty that they're contributing their stuff to the right legal person, right? So when do you form that person? When you have that startup, more than one co-founder, do the math. There's you, that's one. So if you have more than one, that's two. So if you have two or more, then we think you need to actually form a company. Why? Just so that, there are no disputes over who owns the intellectual property and who owns the equity down the road. That's a big issue that comes up. Think Facebook and Winklevoss. So also, when you have a material contract or an obligation, just to limit your personal liability under that contract or obligation. Contracts and obligations can result in big liabilities. What is the best type of entity to form for life sciences, which to me is biotech and medical device and possibly healthcare IT type of company? Almost always a C corporation. Why? Even in the most recent tax reform bills that were proposed, which were not passed, the greater of $10 million or 10 times the purchase price upon exit of the sale of C corporation stock held for 5 years is exempt from capital gains taxes. You can't have LLC units or limited partnership units or whatever, anything else for 3 years, convert into a C corp and hold it for 2 years and satisfy the 5-year holding period. It has to be 5 years. And if you start with an S corp or an LLC that is taxed as an S corp, and then you try to just convert it over and hold that to a C corp and hold it for 5 years, you still don't get the exemption. You have to do this complicated transaction. That's why generally almost 100% of the time, the answer is you should go with a C corporation from the beginning. Second reason why, it's preferred by most venture capitals and angels who do not want pass-through gain and loss. Many venture funds and individuals, they don't want a tax bill for you when you become profitable, right? And that's exactly what would happen. And on the VCs that have not-for-profit investors, then they would get penalty taxes because that's the whole point of a not-for-profit. They're not supposed to profit. Also, the last tax reform bill, 2017, took the corporate rate down to 21%, which is relatively competitive internationally. Now they're proposing 28% again, but we'll see if that passes. In which state should you incorporate? The answer is Delaware. It's a small state. Many Americans have difficulty pinpointing where it is. Doesn't really matter. They have the most corporations, and for example, 90% of new IPO companies, 2/3 of the Fortune 500. Why? Because everybody that works in companies in the U.S., investors, bankers, lawyers, accountants, all the people that that have to, worry about what kind of company it is and what the laws are that govern that, have memorized the Delaware rules, and they do not know the laws and customs of every other state, whether it's California, New York, Massachusetts, whatever. There are these other reasons that you may have been reading. That's also true. It's just the best. It's the best choice, Delaware. Some basic corporate governance concepts for a Delaware corporation. A lot of this stuff is sort of commonly known, but let me give you a little special added value. So stockholders have the power to elect the board of directors. You should think of things as like stockholders on the top, board of directors, officers, and then corporation, and then all the employees and consultants, everything, right? They elect the board by plurality, but keep in mind, as a founder, the majority ownership is not essential for control. Very early on in the process of raising money, because you're dealing with people who you don't know, who just who might be, whose interests might not be aligned with the founders. When you take on investors, you put in place proxies and voting agreements. Proxy is basically where you give where somebody else gives you the right to vote their shares, right? Voting agreement is an agreement where somebody agrees to vote in accordance with your decision, like who's going to be on the board. We put those in place to basically fix who's on the board and who's in control. So, but obviously from an economic perspective, you want to own as much, whatever percentage of the company as you can own. The board of directors, what do? They control the hiring, the firing of C-level officers and all other major corporate actions, selling the company, issuing stock, declaring a dividend. It's okay to have just one director until investors ask for board seats. Because really what the board is about is control. It's not about adding people on to make your company look, better managed. The solution for that is to get advisors, make advisors instead of directors by signing an advisor agreement and providing a small equity grant. If you're going to put more than one person on the board, avoid deadlock in all cases and try to outnumber investors wherever you can if you want to retain control. And then who are the officers? Like the CEO, the CFO, the CTO, the CMO. Those people are in control of the company day to day, but at the board's discretion, i.e. the board can hire and fire all those people. And usually the CEO hires and fires everybody else. Okay, the first major thing you want to do from a structural perspective before you try to raise money in a startup is to paper your cap table, paper up the equity. Why? Because of long drawn out expensive disputes that can happen over the company if it turns out being something that's valuable, and sometimes even when it's not that valuable. Being the lawyer involved in these companies, I see this kind of dispute. It's incredibly inefficient. It's better to resolve things in advance and try to modify them, reasonably with negotiation as things move forward instead of having a dispute. Tax issue. If you raise your equity too close to an equity round, you may create ordinary income taxes for the recipient of the equity and the company. Because if a service provider has an obligation to pay ordinary income taxes, that's also a company obligation. And the way that companies usually take care of that is the way they withhold from the paycheck, right? But if you didn't withhold in the beginning, when you just let's say granted all the founder stock right before a 10 million priced round, thereby giving your entire team 10 million of ordinary income, which that can be disputed to some extent, of course, then that's a big issue, right? Investors require it. They want all equity to be correctly papered prior to the closing of a financing anyway. So why jam yourself up and try to get it all done at the last minute? Usually that's going to result in some big legal fees, tax issues, people leaving money on the table. Try to do it along the way in increments. I deal with this all the time. It saves you a lot of pain and money. All you need is a document called the board consent signed by whoever the directors are, and a stock purchase agreement or a stock option agreement. Simple as that. I'm going to talk about what those are. So before you do your first priced equity round, what is a priced equity round? It means when you sell your stock for cash, thus valuing the stock and thereby the company, right? Until then, you do things like you issue convertible notes or safes, which sort of obscure the value of, or is not setting the value of the company, right? Before that priced equity round, you grant something called restricted stock. It's a term that was coined probably in the Silicon Valley. That's just the time between the incorporation and the priced equity round. This does not include, the second bullet point or third bullet point is saying, when you sell safes and notes, you're not pricing the company. So you can sell restricted stock after you raise $10 million of convertible notes and safes. That means the team member that receives that is basically getting their stock at zero. Much better than, and they're not paying any taxes on that. So it's the best deal from a tax perspective. What is restricted stock? It's just common stock on a vesting schedule, and it's subject to federal securities laws limitations. But you got to file an 83B election with the IRS. 83B election within 30 days of the date of the stock purchase agreement, if the shares are vesting over time. Next, I'm going to recommend they all vest over time. So that, basically you're going to have to file a bunch of 83Bs when you give out restricted stock, but it's well worth it. It avoids a massive tax problem. I don't need to explain it to you. Just conclude that it's massive. Okay, next, after the first priced equity round, you grant stock options. Why? To avoid taxes, bottom line. Not avoid, but minimize taxes. What is it? It's basically a right to purchase common stock at a fixed price, usually for the earlier of 10 years or 90 days after the person leaves. Usually have to get a 409A appraisal, which is pretty available for pretty cheap on services like Carta, other services, to determine the fair market value of the common stock, which is the exercise price. And this is the next best good deal from a tax perspective if you give it to employees, because there's no tax when they get the option. And they're, hopefully if they follow all the rules, then they only have to pay capital gains tax at the end, which is much better than ordinary. Its difference is 25% on capital gains, and it could be like 40, 50% on ordinary income. Equity vesting. It's important for all equity that's provided in exchange for services to vest on a schedule or in accordance with performance of milestones by the personnel. Why? I mean, nobody who's working with you at the company or you should want everybody else to vest, because if they leave early, then they shouldn't keep all their stock. So if you split your stock 3 ways among 3 co-founders, and then 2 of them leave, why should they own 2/3 of the company? You only own 1/3. You should be able to buy that back for nothing. That's the way we set it up. Investors obviously want the shares to vest because they want people to stick around and do the work to build the startup. Typical vesting schedules coming out of the Valley in the 70s and 80s through trial and error, but now are standard all across the country, is 3-year, 1-year cliff, or 1/3 after 1 year, 1/36 each month after that, from the time that you start working on the company. So if you're only documenting this stuff in January 1st, 2022, but you started working January 1st, 2021, then you just say the vesting started on January 1st, 2021, and you're already vested in the 3rd, right? Later joining people, employees, consultants who are not really founders, they usually go on a 4-year, 1-year cliff. 25% after 1 year, 1/36 each month, or 1/48 of the total shares each month after that. Directors and advisors, they usually vest monthly over 2 years. And also consider the non-typical structures, which is where shares vest, let's say, like 10% of the total grant for every million in revenue that the salesperson creates, or for every new version of the software along the timetable that has been created, blank shares, right? It's very useful. Milestone vesting. Next major type of thing that you want to put in place before you raise money for all advisors, consultants, interns, employees, anyone providing services to the company. Those are basically the 4 legal categories, and advisors and consultants are pretty much the same thing. Contractors should sign a service agreement. And the key words are when joining, not after joining. After joining, you have less leverage. I mean, technically you can say you're fired if they're an employee, but you still have more leverage before they join because you haven't even accepted them yet. So why? They all achieve 5 important things. There's a different form for each of these different types of, categories of people because of different legal reasons, but they all achieve the 5 important things. Number 1, they require the person to not disclose your confidential info and trade secrets to third parties, not use it for anything other than working for you. And it requires them to assign all the intellectual property that they created on the job that relates to the business. They prohibit the person, if they leave or even while they're there, from competing with, this word is missing here, competing with your company or soliciting your customers and suppliers, distribution partners, employees, and consultants. It's called non-solicit, within, let's say, 1 year or 2 years after the person leaves. And not to speak poorly about the company or you as the manager on Glassdoor after they. Why? Do you need all these things? Because people will steal your IP and go to a competitor. They'll compete with you. They'll say that they own the IP. And these are all terrible things to have to talk about with your, like A-round investors, the nasty letters you're getting from the former personnel. That would all have been settled had you just got one of these form agreements signed when they joined, and they are definitely forms. Most people sign them without negotiation. You also want to tie the equity vesting I talked about to the duties in the service agreement, so you can basically leverage people to, look, I'm gonna cut off the vesting unless you do what you said you were going to do. And keep in mind, investors will want all current and former personnel to have signed one of these. And it's systematic. If I'm on the investor side, I systematically ask for a list of the current and former personnel, and then I have an associate check the box and make sure that each one of them has signed one. Here are some other important pre-funding items. Use non-disclosure agreements. I already said service agreements, where possible, to protect trade secrets and other confidential information, where possible. Non-disclosures cover the person not disclosing your info or using it for any purpose other than, maybe considering a business deal. Consider filing for patent, trademark, and copyright protection. If you have patents, trademarks, or copyrights that could be valuable, or applications that could be valuable. Confirm a clear IP chain of title. If you have people who are coming in from a university, especially in life sciences, or actually in any industry really, or from another company, and you think they have a lot of IP in their head that is that actually could belong potentially to the university under its IP policy or their employment documents or the former employer's employment documents, you have to get a copy of that and figure out what's going on and figure out what is in their head that is not the other, the competitor or university's IP, and divide that up and not mix that old IP with yours. Have good lawyers draft or review material agreements, forms of customer, supplier, distributor, affiliate agreements like terms of use, privacy policy, any other important deals like joint development relationships or licenses in and out of intellectual property. Because this kind of stuff can get, unfortunately, lots of lay people think that they can negotiate these deals, but at the very least, you should have somebody look at the IP language. And then if you can't resolve your regulatory issues, which life sciences people are probably usually pretty familiar about, if you can't resolve it completely, then at least know the pathway so you can explain it to investors, whether it's 510K, CE mark 510K, phase 2 clinical trials, and then XYZ, all those different lovely life sciences concepts. So did we ever get results on our survey as to who wants to focus on raising money first? I don't see anything on that, except one answer, yes. Well, JJ, are you still here? Do you see a show of hands anywhere?
I'm serious. I see one show of hand. Yes.
Okay. So how are we doing on time here?
Oh, we're doing fine.
We're good. Yeah, we're good. So 4 major areas of IP law: patent, copyright, trademark, and trade secret. What are patents? They are a 20-year exclusive right to prevent others from doing all this stuff: making, using, selling, offering to sell, importing the patented invention. And that obviously has extreme value, but there's a balancing act, because when you disclose your technology to the public, it becomes public. Sorry, when you get a patent, it gets disclosed to the public. So that gives them the ability to create a workaround your technology. That gives you it does give you the limited monopoly on what you have created. And there's also the first to file issue, which means that if you invent something that is patentable and then someone else patents it first, then technically they can stop you from using it anymore. So what a lot of early stage companies will do, since they don't have an infinite amount of money to pay a patent boutique, file a bunch of patents, and we usually recommend you use a big law firm, patent prosecutor that's been referred in by your corporate lawyer. That's me, because that way, they're going to probably be not trying to churn and burn and get you to file as many patents as possible, like a strip mall guy or a boutique might. But one solution is to file a provisional. It's only usually a lesser amount of money, like $2 to $3 versus $10,000 to $15,000. It's pending for a year. You don't have to worry about it being examined by the patent office, but you get the priority as of when you file. You can say you have patent pending technology, and you just have to follow up with a non-provisional filing within a year. What is a patent? They have the utility patent, which protects the way an invention works, design patent that protects the ornamental appearance, and the foreign patent applications, which under the Patent Cooperation Treaty allows you to file in like 172 jurisdictions. But keep in mind there are fees for each of those different jurisdictions. I have an example, which unfortunately is not life sciences, but gives you sort of the concept. Utility patent, system and method for detecting and tracking features and images. You can see it's got a decision tree, for the software. Here, a design patent is just patenting this USB flash drive housing that is depicted right here. Tells you the difference between the two. So what we usually recommend is you just get a free initial consultation from a patent prosecutor for a half an hour to an hour conversation about what you're doing, and help them develop a strategy, whether that's don't file anything at all, file a provisional, go for a full utility patent, whatever makes sense, because they're the experts. And I can set you up with people that can give you that. Just so you know what copyrights are, it's the Circle C to protect works of authorship, things in your head like books, music, like these slides. Like underneath here, there should be a Circle C 2022 Nelson Mullins or Joe Daniels. And from unauthorized copying, distribution, and display. So here's a question for you. Is a genomic sequence patentable or copyrightable? And I believe the answer is patentable. Look and feel of a medical device. I don't know if that's a design patent or a copyright. It's a complicated analysis. You have to go to the IP lawyers for these questions. But it does provide you, it's pretty obvious when it comes to slides, books, music, anything, if you reduce it to a fixed form, that's copyrightable. And you obtain the common law state copyright notice or protection when you put the notice, Circle C, date of publication, copyright owner. That works in all the 50 states. So why would you get a federal copyright registration? And the answer is that you can get statutory damages and attorney's fees in federal court. It's a very severe remedy for the person that infringes your copyright. And it's very easy to do this on your own without a copyright attorney. You simply, select the right form at the USPTO website, deposit it digitally, make a filing fee, and trademarks and trade secrets. So trademarks are names, logos, designs, and sounds that are intended to identify the source of goods and services, famously things like the Nike swoosh, Intel Inside song, that kind of thing. The standard of infringement is substantial likelihood of confusion. And in other words, like if you have, Apple textiles, and your logo is a color apple with that obviously is a massive likelihood of confusion with Apple computers, so substantial likelihood of confusion. You protect your trademarks by just using them in the 50 states. You get common law trademark protection, but if you want to get protection in all 50 states at once, without having sold anything under the mark in, let's say, Texas and the Southeast, then you would file with the U.S. Patent and Trademark Office and you get all 50 states. What we usually recommend is that you, at least before you start building a brand, that you at least search for the usage of that brand, make sure that nobody else in the same industry, similar business is using the same one or something similar, because and maybe they're way ahead of you. And because what will happen is that you build your brand, they find out about it, and they send you a cease and desist letter, and then you take it to a trademark lawyer, and they say you should probably just change the name, and then you have to, redo your entire brand. But after you've done that basic level of search, if you really want to see if your brand is safe to use, you can do a formal database search, which is about $700-800, and then get a trademark lawyer to do an analysis, and they'll tell you, how safe you are to operate. And then if you're safe to operate, then you can actually file for a trademark protection if you think it's valuable enough. Finally, trade secrets. Trade secrets, the famous trade secret is the formula for Coca-Cola, which is hidden in a bank vault across the street from the Coke headquarters in Atlanta. So that's some protection. But what I mean by that is technology is technology that drives independent economic value. The formula has its own value, which is that it tastes really good, and it's subject to reasonable efforts to protect the technology from disclosure. Namely, it's in the bank vault, right? So what should your trade secret strategy be? There's no formal application or filing process. You just have to keep it secret. That's why everybody uses those service agreements I mentioned with the confidentiality provisions, and you might want to also guard access with encryption, etc. Okay, let's start with the raising money, which I hope is more exciting. So we usually divide up seed rounds these days in the early stages into pre-seed and seed. Pre-seed, it used to be called friends and family. It's where you're raising, let's say, $1 to $2 million, selling 1 to 10% of the company. And it's when you have a business plan, some strong founders, hopefully some demonstrated product market fit, but limited traction. And then, so the investors in those rounds are usually angels, local individuals, angel groups, maybe some early seed stage funds. Then the seed round, you're raising more like $2 to $10 million. You're selling 15 to 45% of the company. Obviously, 15% of the company is better than the 45. Which is, it's determined by the valuation. There you usually have, yes, the strong founders, apparent product market fit, but also some meaningful traction. In 80% of these deals now, there is revenue, and $1 million of annual run rate, which is $83K per month for, let's say, 2 months, is often targeted by the early stage VC. So, and this is, these numbers and these medians and everything is going to be skewed across all the multiple industries. But the concept here is that to the extent that you can create any kind of revenue, the better. But anyway, in the seed rounds, the investors are usually, the angels, early stage VCs. And what that means is that there may not be a lead that steps forth, but the investors may invest without a lead. And they do this because you do something called a company-led round, which is you put together a term sheet, you get enough people to commit to it that makes sense to draft the documents. You start getting people to sign the documents and wire in the money, and you put together your $1 million or your $1.5 million without having any negotiation or anything. So usually the way that happens, and sometimes of course there's some people who will negotiate, and it all depends on who the investors are. So what happens is that very often is that my clients will come to me and say, I want to raise 1.5 on this with these terms. What should I do? And we'll work with them to say, well, you should just sell a safe, or you should do preferred stock, or Series C preferred stock, and raise 5 on a 10 million pre-money, or whatever it is. And usually that whatever is being proposed by us is marketable, to the investors that they're going to go pursue money from, and it works with some tweaks, of course. The other way it goes is that the seed round, early stage VC gives you a term sheet, negotiate it, and then you close. We do both types all the time. So just some basic concepts on what is a convertible. The typical seed financing structures: convertible notes, safe, and Series C preferred stock. So why are convertible notes and safes so popular? I mean, the first reason is you don't have to, it's a variable conversion price, so you don't have to decide what the company's value is. You know, if the investor thinks the company's worth 3 million pre-money and you think it's worth 10 million pre-money, how do you get the two sides to meet? It's also much cheaper. These are short documents and they're form documents. So the fees can be as low as a couple $100 or, you know, basically zero now, deferred until you raise, instead of, you know, 10 to 35K for a seed stage preferred stock financing, or, you know, it actually can be even more if you have the wrong investors council involved, right? And or maybe the wrong investors who don't know how to, you know, do this right. And then, of course, after you sell a convertible note or a safe, as I mentioned, you can still arguably grant restricted stock because, you know, your company's valuation hasn't been priced. Why would people sell Series C preferred stock? Number one, the investors don't, because the investors don't they won't buy notes and safes, and they want to set a value on the company that, of course, is as low as they can get it. And you're okay with the price that they are willing to pay. And something, like I said, many investors just won't invest in notes and safes. Or maybe you have a bunch of notes and safes that have been out there for a long time and you want to convert them. And what converts notes and safes is usually Series C preferred stock financing round. With convertible notes, it's of a minimum amount. As I just said, the principal term of a convertible note is that it automatically converts on a minimum equity or priced equity round, right? So let's say you raise 250 or 500K in notes. Those notes will usually provide that if you raise a larger amount in an equity round, then that converts the notes. Like, let's say $1 million. You raise 500 notes. If you raise $1 million in equity, then the notes convert into the equity round. The question is, what is the pricing of that? What is the conversion price of that conversion? And usually, and the best, not usually actually, in maybe 20%, 15% of cases, the safe or the note is a 15% discount, 10 to 25% discount to round price, discount only note, right? And the reason why that's best is because if you are successful, the more successful you are at raising the valuation after raising the convertible note financing, the higher price at which the note holder gets in, right? Note holders figured this out, so they created the concept of the cap, which is a fixed or a capped price between what they think is today's valuation and what they think the valuation at the next equity round is going to be. So if in the hypothetical I gave you, investor thinks you're worth 3, you think you're worth 10 million, why not cap it at 5 million, 7 million, something in between, and then you go out and raise at 10 million and they get in at 7, which is lower than the discount. Or if you raise at 4, then they get in at 4. It's usually lower of the cap amount or the round price. And then, of course, when the investors have their cake and eat it too, they have the lower of the discounted price or cap, called a discount and cap note. So we usually recommend, the first 2 bullets, and probably the most common is this bullet number 2, cap only. And keep in mind that it's important what's in the conversion formula. If you include the other note and safe shares for any other notes that you sell, any other safes that you later sell, similar instruments, that makes the convertible note post money, and then you get diluted a lot more. So therefore, you should try to, like it says, exclude any other note and safe shares from the formula in your own convertible note. The principal amount, of course, determines the eventual ownership percentage. It's one of the variables. Interest rate these days, usually 2 to 6%. It's not usually heavily negotiated because it's not a big component of return, because the typical term of a convertible note is 18 to 24 months. Okay, next, what is a simple agreement for future equity or safe? This is the other major way that money is raised. I think I forgot to say that whether in life sciences or software or whatever emerging company industry, these days the safe is the most widely used early stage financing vehicle, convertible notes probably being number 2. So what is a SAFE? It's exactly the same thing as the convertible note I just described, but it does not have a maturity date or interest, both things that are bad for founders. So why has it become so popular among investors? Not just because the companies are somehow, more hot now. It's because all the safe investors, or the people that used to invest in convertible notes in the Valley found out how bad it was for the companies and for them. Because what they really want to do is convert into the equity. They want the company to raise that priced equity round. So they don't want to get in their way by arbitrarily demanding money back at whenever the maturity date is plus interest, right? And then have that interest continue to accrue for years and years after the maturity date, right? Just not really what the nature of the investment was. They intended to invest in something that would convert into equity. So, and usually these people have more than $10 million, and they'll just accept a write-off rather than trying to get their 50 grand or 100 grand back. And usually the people that are, the so-called weak hands that are demanding their money back probably shouldn't have invested in this speculative of an investment in the first place. The reason why convertible notes can be so painful is because you have those weak hands asking for money back, and then that blows up your operating plans or potential financing round, et cetera. So also you want to use a pre-money safe instead of the current Y Combinator post-money safe that's online to the extent possible. Reason being that, again, all other note and safe shares are included in the conversion price calculation for the post-money safe, which basically ends up diluting the shit out of the founders. I mean, just to make it very simple, excuse my French on YouTube, but some investors don't get it, whether it's investing in a safe versus a note or investing in pre-money. So the solution to people who will not invest in a pre-money instrument is to simply increase the cap, right? To reflect, to try to adjust for that. And if lots of people like me are out there that do emerging company law, they can help you with a pro forma cap table that can help you calculate what the effects are of these differences. Another sort of interesting set of issues in raising money these days with notes and safes is the side letter request. That you should only give the side letters to people who are investing a lot of money, number one. Depends on how much you're trying to raise, making a lot of money concept relative. But, I'm talking about 250K, 150K, 500K, some not just like 25, 50 typical, small investment amounts. So what is usually asked for is number one, most favored nation status. That means if if someone sells you or you sell an investor a 5 million cap safe, and then you sell somebody else a 4 million cap safe, then the 5 million cap safe automatically gets adjusted to a 4 million cap safe. Now the problem with this is that it restricts your flexibility to change the terms of the next financing instrument because the other person's investing more money. So if you sell one at a 5 million cap at 50 grand, but then somebody wants a 4 million cap and they'll give you 600, then you should be able to adjust for the 600K and not give that to the 50K, right? And so most people will reject this, and most of the time investors will back off. Pro rata rights is something that is more commonly given away. Just keep in mind that the more pro rata rights you give away, the more likely it is that you suffer more dilution in the next financing round, and dilution beyond that, which you negotiated with the lead investor. So if you negotiate a raise of, let's say, 10 million on 40 million for 20% of the company, but it's a post-money valuation of 50, and a bunch of pro rata rights people exercise their rights for 5 million, then your effective valuation then becomes not 40 pre-money, but 35, right? So that dilutes you. So you only want to give it away to people who invest a lot of money, right? Pro rata rights. Board or observer, usually never give board seats for any of this. Observer seats are fairly common, but you want to limit that as well to people who invest a lot of money, because you're sharing your confidential proprietary information with all these people. God knows who else is in their portfolio, maybe even your competitors. And you don't want to have a board meeting of like 15 people all of whom are invested and might have a difference of opinion. It's just difficult to manage that at an early stage. And some of them will even ask for a series of blocking rights, like 10 to 15 things that you have to go get their approval for, like selling the company or raising a round. And that is just generally not accepted and doesn't make sense in this context to try to reject it. Next, we're gonna start talking about preferred stock with the lowest level, the earliest stage type, Series Seed. It just means seed round preferred stock. What is the most important term? It is, of course, the price, the pre-money valuation, because that determines what percentage of the company that the investors get. Watch out for price lowering techniques. What I mean by that, basically, investors coming in and ask for a very large option pool to be adopted pre-closing. It's a post-closing number, let's say 20% post-closing, saying that's included in the pre-money, or that's included in the calculation of the per share price. And what that means is that common stock or founder takes all the dilution on that 20%. So if you negotiate again let's say 40 million pre-money, and you adopt that 20% pool, then you have to reduce the pre-money by 20% as the effective pre-money for you in terms of your dilution. Also, the basic debate over whether or not note and safe shares should be included in the pre-money factors into the valuation. Basically, if it's included, then it reduces the valuation for the common stock or the founders. If it's not included, if it's part of the round, then it doesn't. So it's all a valuation question. But that, there's different ways to describe this in term sheets. You have to get somebody to negotiate that part of it to make so that you know what you're giving up. Obviously, investment amount. I say 10 million, but I see seed rounds now easily of higher amounts. That determines the percentage of the company as well, along with the pre-money. Liquidation preference, usually 100% of the time, 1x non-participating. I'm just going to explain this concept one time for you, which it basically means that what is preferred stock fundamentally? It means that on the sale or liquidation of the company, the preferred can get their money back before anything is shared among the common stock. So if there's Series C preferred stock outstanding, the preferred investors invested $5 million, and the company is sold for $5 million. Then they take $5 million, common gets zero. But the preferred can also convert 1-for-1 into common stock. So if the $5 million of preferred, the company is sold for 100 million, the 5 million of preferred is not going to choose. I forgot to say what the pre-money was. Let's say the pre-money is 15, so they have 25% of the company. Then they're not going to take the 5 million off the top. They're going to convert into common, and they'll take the 25 million, right? 25% of the 100 million. That's fundamentally what preferred stock is. They have the option on dissolution and sale of the company, change of control, to take their money back off the top, or their as converted amount, as we call it. If it's participating, they get the money off the top plus their as converted amount. That's why you don't want it to be participating. That reduces in the hypo I just gave you. They would get 5 million off the top of the 100 million plus 25% of 95 million, whatever that is. So they make more, you make less. Usually, you don't give up board seats in the seed round. Sometimes people do. It's better if you just give people an observer seat, because then you don't have to deal with all the worries and dynamics of having an investor, having to vote on everything. Or if you do give up a board seat, obviously it should be a minority seat. You have to think about, if you're the only director, you have to think about what other people you can put on the board that you can trust to outnumber the investor board seat. And then blocking rights, that basically just means the holders of a majority of the seed preferred stock must approve raising new money by the issuance of senior or equal preferred stock, which basically means your next equity financing, which is probably your next financing round altogether. That means they can block your raising new money, right? It's a major blocking right. But usually preferred stock people get it. Investors get it. Sale of the company, dividend or repurchase of stock, changing the size of the board. Those are the main four, sort of the bare minimum that you give up. If you can do without any of these and add on a couple of other, less things of lesser importance, that's even better. You want to just always minimize the restrictions on your taking action. One way to do that in respect of the raising new money or the sale of the company, which are big items, is to say they don't have to approve stuff if the valuation in the new capital raise is over a certain amount, or if the sales price for the company is over a certain amount, right? That's what I mean by these two parentheticals here. Usually there's no anti-dilution protection. Talk about that later. Usually there are sort of minimum major investor rights. If you've invested, let's say, $250K, $500K, then they get information rights and pro rata rights, which is basically, some rights to see whatever unaudited or maybe even audited financials that you produce, as well as a right to buy a percentage of the next round, which we talked about in connection with the side letters. They also will often ask for vesting restart, which means, they'll just put in the term sheet that everybody in the company, including the founders, are going to vest on a 4-year, 1-year cliff schedule from the time of the closing, even though you were already building the company for 4 years and you're fully vested. That's what a vesting restart is. And it's more commonly aggressively asked for on the East Coast than the West Coast, but happens all over the place. And, sometimes there's, sort of a reason for it, like you just pivoted to a new business model. But what I always recommend is that you start with a reasonable schedule when you put your stock, agreements in place, like a 3-year, 1-year cliff from whenever you started, and then just try to fight them off. The best argument is, this is my baby. I built it. I'm not going anywhere. You don't need to put a vesting schedule on me to incentivize me. And, that's ridiculous. I've earned this, et cetera. Plus the standard vesting schedule in the Valley or these types of companies is 3-year, 1-year cliff for founders, et cetera. Next, the A round. The A round, only a few, very small percentage of companies get to the A round. I don't know. I haven't seen that number recently. So what are the characteristics? You have the obviously strong founders, but also an appropriate team. Not only the demonstrated product market fit, but and that means, which I never explained, a market ready product that clearly addresses the intended large addressable market, but also at least 2 to 5 million in annual run rate, depending on industry, at least for a month or two. And that again, these I have to give you median statistics because it's difficult to get data, by industry. But sort of concept is usually the revenue criteria for the A round is going to be higher. Obviously, if you're in biotech, you're so far away from revenue most of the time that is of lesser importance. The round sizes are usually 5 to 80 million. You can see the median for a recent quarter was 12 million raised, so a good size financing. Valuations median, 37.4 recently, but we're now seeing, 30 to 800, depending upon how hot the company is. Who are the investors? It's venture capital funds and private equity funds and strategics to a lesser extent. And then also, of course, the prior round investors with pro rata rights. All these numbers are, especially this 800 number I'm giving you here, are skewed by mega rounds, especially in biotech. Mega rounds are 100 million plus rounds, and the number of those has gotten huge. So all the median numbers are a little bit off, but gives you an indication. So how do the terms change from that Series C round that I was just talking about? The pre-money valuation question is always the same. You try to keep the equity plan smaller that people request because that dilutes you more. And then you try to exclude the note and the safe shares, like I just explained. And of course, otherwise negotiate the highest price. Liquidation preference is still almost always 1x non-participating, like it was in the seed round. You usually have to give us a board seat away, though. Here are some typical board structures that you commonly see in venture rounds. Obviously, the cleanest type is one where there is no board seat. But since you're probably giving one up, I'd say 2 founder seats, 1 VC seat, right? Obviously, then the founder controls. That's the same as 3 founders, 2 VCs. Next, 1 founder, 1 CEO, 1 VC seat. Then the founder controls unless the CEO departs, whether that's due to some scandal like Uber or just resignation due to having some health issue or something. So that's the same as having, and obviously then you lose control, right? Or actually, if the CEO seat resigns, you don't have any CEO, you have deadlock, then we have the new CEO, then which is selected mutually by the VC and the founder seat, then you might have control again, but you might not. And that's the same as 2 founder, 1 CEO, and 2 VCs. And then, so on and so forth. I'm not going to get into it, but you can look at these slides and think it through. Basically, you want to come closer to here than down to here. You're starting to lose control here. Right? 1 to 3 are most commonplace. Investors, here's a great point, are usually buying a minority position in the A round. Like I said, or maybe I didn't say the percentages, but if you figure out the round price on top of the size of the round on top of the valuations, you can see it's a minority percentage. So that why should they have control? Meaning usually over 50% ownership implies that you should have control. Also, that list of blocking rights, expect to give at least the same as you did in your seed round, but also more. And then the game is to try to limit it as much as possible. Restrictions on everything from, affiliated, related party transactions with yourself and your team, borrowing money, forming a subsidiary, all this list of things, all of which can, be sort of difficult when you want to do something and your investors don't. You also have to usually provide the Series A investors anti-dilution protection, meaning if you sell stock at a price that's lower than their price, then their conversion price adjusts, so they no longer convert 1 for 1, but like 2 for 1, 1.3x for 1, which is not good for you. So the key is to negotiate these carve-outs. Look at the National Venture Capital Association Standard Certificate of Incorporation, and it'll give you a gigantic list of carve-outs, which we try to get in every deal. You also want to try to limit those major investor rights, which is the financial information and inspection plus pro rata rights. Again, you want to try to limit this to the smallest number of investors so that you suffer less of the potential negative ramifications of, sharing your information and taking the dilution on pro rata share rights. Stock purchase agreement contains a bunch of reps and warranties. You have to pay more attention to all of these representations you're making, because if you breach them, then claims can be made, and usually that results in a reduction in founder share percentages. The A-round investors get, basically 100 pages of new rights, registration rights, right of first refusal and co-sale rights, voting agreement rights, lots of rights. And then you need somebody to help you, try to make those a reasonable list. Next, we're going through the B plus C, and then strategics, and we're done. So right on schedule. I'm gonna whirl through this though, so we have time for Q&A. So on the B round, again, the round sizes are sort of the same actually. The fourth quarter 20 median was 32. I have to update these numbers a little bit. Median valuation 115, but again, we're seeing the 60 to 800. Over $1 billion in many cases with the unicorn market. The investors are, again, the VCs and the strategics, but also hedge funds, experience with later stage. A big mutual fund companies like Fidelity, they start playing in the B round. Numbers are, again, skewed by the mega rounds. But think about, what do you use the proceeds for the A round? You hire a much larger team, you expand into different verticals and revenue streams, you acquire companies, you become more of a company as opposed to just a one product thing that has started to make a lot of money. What are the differences in the B and the C and the D and the E, blah, 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 going on up to space N, preferred stock for SpaceX? Same issues with the inclusion of more note and safe and equity plan shares. There's that, you have those issues in every deal. Liquidation, but basically, usually all of this stuff is included in the pre-money, and the pool size keeps getting bigger to build a bigger and bigger team. So the key point is to negotiate a higher valuation. Liquidation preference still usually 1x, non-participating, but around 10% of the deals started to have participation. 68% of those were uncapped. So if you give away participation, you want that to be capped, because again, that just leaves more for you. Cumulative dividends, most deals are still non-cumulative at this stage, going up all the way up to Series N, but about 5% of the deals have a coupon, and that basically reduces the amount that the founder owns of the company on a day-to-day basis in many cases. So you want to try to avoid that at all costs. The board seat game is that leads VCs from the prior rounds and the new rounds, they all want to get a board seat. So you have to keep increasing the size of the board. It makes it more likely that you're going to lose control. But if you have cemented a position as being the person who is really driving this company to great success, then it is conceivable that you would be okay with that. At the same time, why should you? So you just have to keep identifying new people that would be friendly to you on the board, and to the greatest extent possible, keep the ability to designate those people an individual personal right rather than a right of, let's say, holders of majority of the common stock, or the common stock that held by people who still work at the company, right? You don't want to go that direct. It's better if it's just like founder name has the right to designate these 5 directors. And then, of course, early, you try to pressure the early stage investors off the board. In terms of the blocking rights, it tends to get sort of fixed at what the A and the B round were, and you don't have to renegotiate over and over again. But as you get more and more directors on the board and more investors who have different divergent views, try to insert things like, unless this stuff is approved by one of the 4 preferred directors, or unless 60% of Series A, B, and C all agree, then you don't need to do. Then you don't have to get this person's approval. You just have ways of making it a more democratic process, as opposed to one arbitrary VC or investor having the ability to block the company action. Everything else is generally a copy of the A round documents and rights, and then just a little bit on the C round. Bigger medians and means in terms of the amount raised, 60, sort of like 60 instead of 30, but it can easily be 100 million plus. Valuations don't go up that much on a mean basis, but of course they do on an actual. And that what's required for that is really more of a completely de-risked company, ready for large scale expansion, either internationally or by acquiring all of the competitors. And the investors, late stage VCs, private equity, hedge funds, and banks. That's when things start to get, a little bit less negotiation on all these, things we talked about, and it's more about the price. Finally, strategics, very interesting stuff for a life sciences company. So generally the deals are exactly identical to the A, B, or the C plus round, except the strategic will use usually they're going to try to get commercial rights with the financing, or in exchange for a connection with the financing. What is that? Everything from discounts on your product to exclusivity in respect of, distribution in certain markets, most favored nation rights on purchase of your product or service, special supply or distribution terms, research and development collaboration, all these different types of things, depending upon what the potential partner is. Probably the most important thing in a strategic deal, in my opinion, is where the strategic investor is asking for these special rights in connection with your potential acquisition, the potential acquisition of the company, right? So it ranges from sort of best to founder to worst. Right of first offer is merely an obligation of the company before it tries to go and sell the company to let the strategic make an offer for 15 to 30 days. So the strategic makes an offer within that period, the company can just simply reject it. Right of first negotiation adds to the right of first offer and obligates the company to negotiate in good faith for 15 to 60 days after receiving that offer under the right of first offer. So then you have to negotiate in good faith. You have to say, well, we understand what you're saying about that price, but we think because of these, comparable companies and, multiple revenue earnings and revenue multiple analysis, discounted cash flow, it's actually going to be XYZ more. Right of notification, it's a little bit more restrictive. It obligates the company to notify the strategic anytime you get a bona fide acquisition proposal, and then you will not enter a no shop with that potential bidder for 10 to 30 days. So the strategic has a chance to, and so, obviously you have to then tell this other bidder, oh, I'm sorry, we've given a right of notification to the strategic. We can't enter into a no shop with you and lock in our deal that we prefer to go with you, but we have to negotiate with our strategic. And then strategic can add in a right of first negotiation with that. And it becomes, then you have to negotiate in good faith and things become a little bit more dicey. Finally, the right of first refusal is just an obligation to let the strategic match the same terms offered by a bona fide third party. Why does it get worse? On the next slide, I explain. Basically, buyers don't want to spend the effort, time, and expense to do all the diligence needed to work up a bid. I'm bidding on doing the diligence on a buy-side M&A deal for a $50 million company. And it's basically going to be $35,000 just to figure out the legal and markup and acquisition draft. So that's a fair amount. And then on the business side, there's, let's say another 25 grand or 50 grand of expense or time and expense. Because basically the strategic, once you make that offer, can just match the price and take the entire deal and just lost all your money, right? How do you solve this? If you go with the right of first offer and add the right of first negotiation, if you have to, then that's not that restrictive. And then the third best is that right of notification. The worst, the right of first refusal. You really don't want to give a right of first refusal ever, and most of the time you can fight that off. It's obviously stronger to limit any of these rights or have them terminate on a qualified financing, acquisition, or IPO, and it's weaker if it's limited only to when you're shutting down the company or winding up the company, but not when you're selling the company. So with that, I have 5 minutes on our scheduled calendar for Q&A.
All right, I'll start with one. Thanks, that was really good. I don't know how you got through it all and that fast. That was pretty good. My first question is related to the liquidation preference and the participation, non-participation. I think you mentioned in the BC, you don't see participation, you see non-participation. So I don't see the upside for investors. Is this also the same for pre-seed, seed, and A, or you're just saying it's for B and C and above?
No, I mean, across the board in 2021, from the seed all the way to Series N, it's usually 1x non-participating. But remember, that does allow the investor to convert and get the as converted value. So that what they're focused on is what percentage of the company they're going to own. If after the $10 million round, they own 20% of the company, and then the company gets sold, and the company is sold for $1 billion, then they get 20% of $1 billion. That's a really giganto return, right? They don't, who cares about getting their $10 million back first, right?
Okay. Well, that's okay. Just to make sure I understand it and everybody else. So when we do one-time preference, they're going to get their money first. And then my understanding, participating is if non-participating, then you don't participate in the common, right? Participating, you do.
No, I'm sorry, JJ. That's a misconception. So
okay, good. So that's
in
good.
The typical 1x non-participating, what it means is that the investor gets the greater of the money back or as converted amount. So the 5 million in my hypo or the 20 million, right?
Got it.
And in the participating, they get the 5 million. They get the it's not greater up. It's you get both. You get money back plus as converted amount. That's the difference.
Okay. All right. So my misconception was I didn't know in the non-participating was the greater. I thought it was just one, which means they get their money back only. But it's one or the other, whichever is greater. With the participating, they get both. Got it. Okay. That makes a lot more sense now because it's either or. And I thought it was only just their money back. So
don't worry.
Got it.
You should still make a lot of money on those investments. No worries.
Oh yes, yeah, exactly. All right. So we have a bunch of questions in the Q&A. If you could see that, maybe you can go through them quickly. Yeah.
Okay, is software a patent or a copyright? It can be a patent, but it's difficult to get a software patent. Usually it's called a business process patent. And if it is not patentable, it is copyrightable. What is the administrative burden associated with a safe, convertible note, and Series A? For example, how much do we need to report to the investors? So typically with a note or a safe, there is no information reporting requirement unless a side letter is negotiated, which has information rights. And again, you should limit that to people who, and that's from Nicholas Lim, by the way. Series A, on the other hand, like I went through those slides, requires usually both monthly, quarterly, and annual, at least unaudited GAAP financial statements. And usually there's a requirement to start delivering audited financial statements like within a year. So it's quite different between, and then Series C is somewhere in between, maybe only quarterly and annual, and it's definitely just only has to be unaudited so you can use QuickBooks. Good to see actual examples of different conversions. You got it. Taking out the mega rounds, what were recent means raised in Series A? Well, I had them up on, no, I can't find that data. I can't find it. People are always collecting just the aggregate data. As a founder, I often hear about being coachable, which I perceive as giving investors a bigger voice. Should I value much about investors beyond their money? Yeah, I think you should. Well, you should at least try to find some that can add a lot of value. A lot of investors basically can introduce you to a lot of potential partners, especially in the life sciences side, not to mention other investors.
Oh, yeah.
We talked about liquidation preferences, but basically what that means is the amount of liquidation preference is the ability to get at least your money back when you have preferred stock, when you invest in preferred stock. And if you have notes and safes that convert into preferred stock, their liquidation preference is equal to their conversion price. And we talked about the difference between participating and non-participating in connection with liquidation preference. But once again, what that means is in the non-participating context, you get the investor gets the greater of their money back or their as converted amount, whereas in participating, they get both. So if they get both, that's going to hurt you. So avoid the participating and go for the non-participating, because in almost 100% of deals in the US, it's non-participating.
Yeah, very, very. I think there's one more question in the chat. What would you be concerned about in negotiating a pre-seed collaboration with a strategic who will assist with product development and clinical trials and is asking for equity and royalties in return?
Does that mean there's not even going to be an investment? The only reason why they get the equity is assisting with product development and clinical trials? Or is it also some cash? Okay.
That's right.
The bottom line, what I would be concerned about is the valuation at which they would get that equity. Like if you're the valuation of your company and your pre-revenue, pre-trials is 500 million, then it's not such a big deal to give them $1 million of equity, which gives them such a small percentage of the company, right? So it's all about setting the valuation and pricing this correctly and making sure that under the product development and whatever agreements are there, service agreement and license agreement, they're actually required to perform all that. Because a lot of companies like that will try to bully you into accepting agreements that don't really require them to do very much, and then they help you as long as it seems to make sense to them.
Yeah, as you see, Joe truly knows his stuff. So these slides, along with this entire presentation, will be available on YouTube tomorrow. Please reach out to Joe. Joe, you have your information in the slides, right?
I do. Yep.
Yes. So please reach out to Joe for any help. He's been doing this for a long time, and I could tell you he's helped a lot of companies that been part of the Pismo Ventures and others as well. So please reach out to him for any assistance. Joe, thank you very much. This was just absolutely fantastic. You got it, JJ, and best of luck with everybody with the rest of this symposium. I'll see you guys later. Thank you very much. And just to let you know, all the rest, there is more events coming up today. There's 2 more. One is a webinar, the other one is an expert panel. So you're all part of it. Join.